If one continues to view the case of the National Stock Exchange as a public authority, one would peruse the matter in looking at when the National Stock Exchange was incorporated as a company. And one would notice that it was incorporated on 26 November 1992. It was created as a company and was registered under the Companies Act, the then Act of 1956. And if one looks at the memorandum and articles of association, one would then peruse who the promoters and subscribers were. Interestingly, the promoters of the National Stock Exchange were public sector corporations and their representatives. Now, the Central Information Commission and the Delhi High Court, single judge. So the CIC judgment came in 2007, and the Delhi High Court single judge, Justice Sanjeev Khanna, affirmed the decision of the CIC. He agreed with the decision of the CIC, and they held that the stock exchange is performing a public function and is a quasi-governmental body working under the statute and exercising statutory powers, and hence must be declared as a public authority. Now, the basis of the judgment delivered by the Delhi High Court prominently was based on the fact that if one looks at the term of public authority, it has to be given a very broad and a wide meaning. And it should not only include those bodies that are owned and controlled and substantially financed by the government, but also those bodies that actually work to the benefit of citizens, and where there is substantial public fund and substantial advantage to the citizens must be able to seek their right of information against such institutions. And hence, the accountability and the transparency and openness that is required of institutions should not be only restricted to public authorities as such, but may be extended to private organizations which have a public function to do. Now, Justice Sanjeev Khanna here referred to Article 12 of the Constitution of India, which defines the state, and he also referred to the Ajay Hasya case, which had laid down the test to determine the test of accountability under Article 12 of the Constitution of India. It is very clear from the discussion from the judgment that the relevant test that is generally adopted by the courts, especially under the definition of state under Article 12, while one looks at the International Airport Authority case, it is clear that that the entire share capital of a corporation, if it's held by the government, right, it would definitely indicate that it is an agency of the government. Where the financial assistance is from the state and the expenditure of the corporation is some kind of some kind of an accountability is established vis-a-vis state, then such corporations should also be brought within the ambit of state. Now, the third one is very relevant and important here, that if one looks at the case laws under Article 12, it says that where a corporation enjoys a monopoly status, which the state has conferred or is the state has protected, then such institutions, though not established by the government, must also be accountable under the Constitution and accountable under the transparency laws. It is also the functions of the corporation if they are of public importance and closely connected with government functions. I think this is very important. If the functions of a corporation are closely connected with government functions, but because of the liberalization of the economy, the privatization of the economy, you will notice that the government is slowly trying to shed away from its primary responsibilities in many aspects, and they're looking at privatization of such institutions as well. In those cases, when a private institution's function is closely connected with a government duty or a government function, then it is a very important factor to classify such corporations as an instrumentality of the state. It's not state, but it's instrumentalities. So to that extent, I think such organizations should be covered under the accountability regime. Also, wherever the state government exercises deep and pervasive control, that is a great indication that the corporation or that entity must be declared as a state entity. And hence, Justice Sanjeev Khanna also looks into the constitutional development in the International Airport Authority case he also supports the fact that there are chances that the Department of Government may be transferred to a private organization. In such cases, the dilution of transparency cannot be justified. So it is important to look at the public function test. Though you cannot say that the public function test is an exclusive test, but nevertheless it is a very important one. And when you apply the public function test, then in those circumstances, institutions that are like charitable institutions or institutions like stock exchanges have to bring in a sense of public duty and public accountability. And hence, running a stock exchange, regulating the affairs of a stock exchange is a matter closely connected with government functions. And hence, against the stock exchange, that there is a power of judicial review, there can be an abuse of power, there can be a neglect of the duty, and hence it is important that such institutions are brought within the domain of public authority, is what the single judge had to say. Interestingly, the judge also looked into the SEBI Act. He looked at section 29A, and he also looked at how SEBI has granted recognition and registration to the National Stock Exchange and has delegated and authorized the National Stock Exchange to act on behalf of the central government. Such kinds of recognitions that are granted, or such kind of delegation of authority of SEBI, which is an organ of the government, which is a regulator in the stock trade market, will clearly have to bring in a sense of accountability under the Right to Information Act. And I think these were some of the reasons, and this went a long way to bring other stock exchanges like the Jaipur Stock Exchange, the Delhi Stock Exchange, within the domain of public authority under section 2H of the Right to Information law. However, one should note that the single judge decision of the Delhi High Court unfortunately was granted a stay by the divisional bench headed by the then Chief Justice of the Delhi High Court, Justice Madan Lokar. And as I speak today, this decision continues to be in a limbo, and there is no final decision that was delivered by the Delhi High Court. And unfortunately, till such decision is given, the stay operates, and as the stay operates, the National Stock Exchange is not under an obligation to give information under the Right to Information Act, and the citizens unfortunately are unable to exercise their right in demanding transparency and accountability from the institutions of the stock exchange. So that is where the stock exchanges lie in terms of the accountability under the RTI Act, and hence you will notice that there is differing opinions among the members of the commission or the judiciary, as the case may be, because the divisional bench of the Delhi High Court was not convinced by the ratio given by the single judge, and they thought it would be right for the current situation for granting a stay against the order so that the RTI is not operationalized within the stock exchanges. So all the stock exchanges sought this injunction or the stay, and they have been successful in doing the same. And it's been more than 4 years right now that the stay has not been vacated, or a final decision on the same has not been done. So that is where it lies right now. Interestingly, the Central Information Commission has ruled that commodity exchange does not fall within the RTA Act. Now, the Central Information Commission said that the commodity exchange unfortunately lacked finance from the government, and for that reason they decided and ruled that the commodity exchange is not a public authority. So this is probably where one realizes that under the net of public authority, some institutions are brought in and some institutions have escaped the net. Now, those institutions that have escaped the net have no obligation whatsoever under the RTI Act, need not appoint the PIO, need not pursue proactive suo motu disclosure, cannot be held liable for misleading false information, and transparency cannot be ensured from such organizations, is what one will have to say. So the test of public authority is a challenging test. It's a very interesting and a dynamic test. And please note, while objectively certain rules can be laid down by the court from time to time, they have to be subjectively applied to the organization. Vis-a-vis lifting of the corporate veil of the organization, seeing who the promoters were, who is behind the organization as the established members, how is the finance being done. So I think unless that is totally something that can be convinced to the members of the commission or the judges in the High Court, the institutions will not be declared as public authorities. Interestingly, the CIC in 2008 had clearly said that UTI is a public authority under the Right to Information Act. Now, this is also some very interesting, because UTI manages funds as mutual funds, and it's a trust which manages the same. However, because government is a major sponsoring agency in UTI, it was clearly brought within the ambit of the Right to Information Act.